What happens at a DUI preliminary hearing in Pennsylvania? So you got a notice in the mail, preliminary hearing, date, time, location. And now you're trying to figure out what that actually means. What's going to happen when you walk through that door, whether you could go to jail, whether you need to say anything, and how serious this is. Here's the good news. A preliminary hearing is not your trial. Nobody is deciding guilt or innocence that day. But it's also not just a formality. And walking in without understanding what this hearing actually does can cost you. I'm Sean Quinlan, Pennsylvania DUI attorney based in Camp Hill. Let's walk through exactly what a DUI preliminary hearing is, what happens step by step, and what it can actually change in your case. So what is a preliminary hearing? A DUI preliminary hearing in Pennsylvania is an early court proceeding where a magisterial district judge decides one thing. Does the Commonwealth have enough evidence to move forward with your case? That's the whole job. It's not a trial. Nobody's deciding whether you're guilty or innocent. Nobody is weighing every possible defense the way a trial court would. The judge is asking a much narrower question. Is there enough evidence here, if believed, to support these charges and send the case up to the Court of Common Pleas? If the answer is yes, your case continues. If the answer is no, charges can be reduced or dismissed. Think of it like a screening step, a checkpoint, not the finish line, the first gate. That matters because a lot of people walk in expecting a full opportunity to tell their side of the story. Usually that's not what this hearing is for, and misunderstanding that going in leads to mistakes. Why this hearing matters more than it looks. Here's what surprises people. A preliminary hearing can shape the rest of your case in ways that aren't obvious on the surface. Early look at the evidence. You get to hear how the officer describes the stop, your driving, your speech, field sobriety testing, chemical testing, and arrest. That matters. Details fade. Stories sometimes shift. What gets said under oath at this hearing becomes a reference point for everything that comes later. Negotiations, motions, and trial. Leverage. If the officer's testimony sounds thin, confused, or inconsistent, that changes the tone of the case entirely. If the evidence sounds strong and clean, that tells you something important too. Either way, you're learning where the pressure points are early, not months later after the case has already picked up momentum. Strategic value. Even if your case is heading toward A or D, a plea, or another resolution short of trial, what happens at the prelim can still affect timing, credibility, and how the prosecutor values your case. This hearing is never just paperwork with chairs. Where it happens and what the room looks like. Let me set the scene so you're not caught off guard when you get there. Most prelims in Pennsylvania happen at a local magisterial district court, not a large dramatic courtroom like the ones on television. In central PA, that often means a smaller district judge's office, a waiting area, a front counter, a modest hearing room. You may spend part of your morning sitting on a wooden bench outside a small courtroom, waiting for your case to be called alongside several others. Inside, the main people are usually the magisterial district judge, the arresting officer, court staff, a representative for the Commonwealth, and your lawyer if you have one. Other defendants and attorneys may be in the room too. Multiple hearings are often listed for the same morning. The setting can feel almost too ordinary for something this serious. Don't let the small room mislead you. What happens there can affect your license, your record, your job, and the direction of your case. Step by step, what actually happens? Let me walk you through the hearing itself. Arrival and check-in. You arrive early, go through basic check-in, and wait. Several cases may be scheduled in the same time block. The waiting is often longer than the actual hearing. When your case is called, you go into the hearing room. The officer's testimony. In most DUI cases, the arresting officer gives the main testimony. That typically covers why your vehicle was stopped, what the officer observed after making contact, any statements you made, field sobriety testing, the arrest itself, and what happened with a breath or blood test request. Here's the key thing to understand. The Commonwealth is not trying to prove the case beyond reasonable doubt at this stage. The legal threshold is much lower. The judge is deciding whether there's probable cause, enough basic evidence to show a crime likely occurred and that you're the person that did it. In many cases, the officer's testimony alone is enough to clear that bar. Cross-examination. Your lawyer can question the officer, and this is often where the hearing becomes genuinely useful. The goal is usually not to win the whole case right there. The goal is to test the story, Pin down details, expose weak spots, and preserve issues for later. Was the officer vague about the driving pattern? Is the timeline for observation and testing sloppy? Does the reason for the stop sound thinner once it's spelled out under oath? Those things matter. The judge's decision. At the end, the judge rules. In most DUI cases, the charge are held for court, meaning the case moves to the Court of Common Pleas. Sometimes charges aren't reduced. Sometimes they are. More rarely, some or all of the charges are dismissed because the Commonwealth didn't present enough evidence even at this early stage. That does happen, but not by accident and not without someone pushing for it. Common questions before you walk in. These are the questions I hear constantly before preliminary hearings. Let me answer them directly. Will you go to jail at the preliminary hearing? In most DUI cases, if you were already released after arrest, you won't be taken into custody just because you showed up. That's the normal pattern. The catch: a bench warrant, a bail problem, a probation detainer, or unusual facts in your case can change that. So the general answer is no, but not always. Will you have to testify or explain what happened? Usually no. And treating this hearing like your chance to personally explain everything is almost always a mistake. Anything you say can affect the rest of your case. Your lawyer challenges the Commonwealth's evidence without you handling over your own testimony early. In most situations, your lawyer does the talking. Will you get your blood test results that day? Not necessarily. In blood draw cases, especially drug DUI cases, lab results may still be pending when the hearing happens. That does not mean that the hearing can't move forward. Charges can still be held for court based on officer observations, driving behavior, physical signs, and statements, even without final lab results in hand. Will you have to wear an alcohol monitor? Usually not as an automatic result of the preliminary hearing. Alcohol monitoring is not typically imposed just because the preliminary hearing occurred. But bail conditions vary, and related orders can include restrictions depending on your facts and prior record. What a lawyer actually does at this stage. A good lawyer at a prelim is not just standing beside you waiting for the next date. There's real work happening. Spotting problems with the stop, arrest, and testing. A DUI case starts before the officer reaches your window. Was there lawful reason to stop your vehicle in the first place? What did the officer actually observe? Were field sobriety tests administered properly? Were chemical test warnings given correctly? Were there timing issues or chain of custody problems with a blood sample? These issues don't always get fully litigated at the preliminary hearing, but identifying them early matters enormously for what comes next. Locking in testimony through cross-examination. If the officer gives one version of events now and a cleaner version later, that gap becomes useful. Testimony under oath at this stage becomes a reference point. Times, distances, observations, and specific wording can all matter in motions, negotiations, or trial. Working on practical issues. A lawyer who also handles bail concerns, scheduling, local filing requirements, and early assessment of where the case is heading. ARD, suppression motions, plea discussions, or trial strategy. Small missteps at the front always have a way of following the case forward. Early guidance helps prevent that. Preliminary hearing versus trial, the difference that matters. This is the most common misunderstanding in DUI cases, and it's worth being direct about it. A prelim is about screening. A trial is about deciding guilt or innocence. At the hearing, the burden is on the Commonwealth is very low. Testimony is limited. The judge is only deciding whether the case should move forward, not whether you're guilty. At trial, the burden is much higher. Witnesses can be examined in depth. Evidence rules become more decisive. The final outcome is on the line. A simple way to think about it: the preliminary hearing is checking whether the key fits the lock. The trial is opening the door and seeing what's actually inside. So if your charges are held for court, that does not mean you lost your case. It means the case survived the first checkpoint. There's still a lot of road ahead, and a lot that can still change. What happens after the hearing? If your charges are held for court, the case moves to the Court of Common Pleas in the county where the arrest happened. From there, the process typically moves through formal arraignment, pretrial conferences, discovery, which means getting police reports, lab records, video, and certifications, possible suppression motions, plea discussions, and trial if needed. If you're a first-time offender, you may be focused on ARD. That's understandable. It can be a strong outcome. But the preliminary hearing still matters even when ARD is the goal. The charges still need to be processed correctly. The facts still matter, and early mistakes can affect your record, your license, and how your case gets handled before any program is offered. If you're facing a repeat DUI, a high BAC case, a drug DUI, or a CDL issue, the stakes climb fast at every stage. Mandatory minimums, commercial driving consequences, and professional licensing concerns don't wait for the criminal case to finish. Early hearings matter more in these cases, not less, because you're protecting parts of your life that sit well outside the courtroom. A DUI preliminary hearing in Pennsylvania isn't your trial, but it isn't nothing either. It's the first real court stop in your case, and what happens there can shape what comes next in ways that matter. Once you understand what the hearing is actually for, the fear usually turns into something more useful. Focus. And focus is a lot better to carry into that magistrate's office than panic. Practical tip before you go: wear clean, respectable clothes, arrive early, bring your paperwork and photo ID, keep your phone silent, and be polite to court staff, and let your lawyer do the talking. If you've been charged with a DUI in Pennsylvania and you want to understand what your preliminary hearing means for your specific case, reach out. Free consultation, no pressure. Link is in the description. Subscribe for more straight talk on Pennsylvania DUI law. See you in the next video.